Kinds of evidence. Evidence. Evidence in law refers to facts, documents, or statements given in legal proceedings to support or prove the truth of the claim or confirmation. It plays an important role in determining the validity of allegations, influencing the judicial process and ensuring the integrity of the legal process. Evidence, documents can be used in many ways, including physical objects, references, testimonials, and digital data. In court, the admissibility, accuracy, and reliability of evidence are evaluated to determine its significance and relevance to the case. Summary of evidence helps ensure that only reliable and relevant information is taken into account, enabling the law to reach fair and informed conclusions. Definitions. The following are definitions of evidence. William Blackstone. Evidence is that which demonstrates or helps establish the truth of a fact in question. It includes all the means by which any alleged matter of fact, the truth of which is submitted to investigation, is established or disproved. Bouvier's Law Dictionary. Evidence is that which demonstrates or helps establish the truth of a fact in question. It includes all the means by which any alleged matter of fact, the truth of which is submitted to investigation, is established or disproved. Black's Law Dictionary. Evidence refers to the means, sanctioned by these rules, of ascertaining in a judicial proceeding the truth respecting a matter of fact. It embraces all the means sanctioned by law for ascertaining in a judicial proceeding the truth respecting a matter of fact. Importance of evidence. Evidence is the basis of justice and provides a true basis for a fair decision. Make legal decisions. It ensures justice, accuracy, and objectivity in resolving disputes and deciding the truth. Reliable evidence supports claims, guides courts to reach informed conclusions, and prevents wrongful convictions. It allows both parties to present their cases, protect their rights, and prevent interference. Evidence can increase confidence in the rule of law and strengthen the principles of transparency and accountability. Finally, evidence is essential to uphold the rule of law and ensure the fairness and legitimacy of the judicial process. Kinds of evidence. Evidence take many forms, each with a specific purpose, which is to present arguments and help the court make a fair decision. Below are the different types of evidence with examples. 1. Testimonial evidence. Testimonial includes the statements of witnesses who provide first-hand information or expert opinion. For example, eyewitnesses can play an important role in a criminal case where someone directly observes the event and repeats it in court. Similarly, experts such as lawyers or doctors provide expertise to help courts understand complex issues. For example, in a murder case, a doctor may testify about the cause of death. 2. Documentary evidence. Documentary includes written documents, transcripts, and correspondence that provide clear evidence. Contracts, emails, letters, invoices, and official reports all fall into this category. For example, in a conflicting contract, the parties may draft the contract themselves to specify the agreement. 3. Physical evidence. Physical evidence is about information. This includes weapons, clothing, fingerprints, and anything else related to the incident being investigated. In a theft case, the stolen property seized by the defendant can prove a physical connection to the crime. 4. Real evidence. Real evidence refers to physical objects that are directly related to the incident and provide preliminary information. These are sent to the court to prove the physical reality of the situation. For example, a car damaged in an accident may be presented as factual evidence to explain the impact. 5. Indirect evidence. Indirect evidence does not directly prove the truth, but makes reasonable inferences about the truth. It involves making decisions based on the circumstances surrounding the case. In the case of arson, the presence of accelerants and burning patterns in a building may be evidence that the fire was set intentionally. 6. Hearsay evidence. Hearsay evidence includes statements from people who were not present in court, and is often considered less reliable due to inaccuracies or manipulations. It is not usually included, but there are exceptions, such as when the conversation causes immediate anxiety. For example, it may be considered an exception if the victim reports the death to the police. 7. Expert evidence. Expert evidence is provided by people who have expertise in a particular area relevant to the case. Their testimony helps courts understand complex issues. In patent infringement cases, experts can explain complex concepts to help judges and arbitrators understand the validity of the patent. 8. Direct evidence. Direct evidence reveals facts without the need for imagination. It gives clear and concise messages. For example, video surveillance capturing a suspect shoplifting can be used as direct evidence of the theft. 9. Demonstrative evidence. Demonstrative includes images, diagrams, photographs, or videos that can help clarify complex information. In complex medical situations, visual simulations explaining surgical procedures can help the decision-making team understand the complexity of the situation. Conclusion. In the legal context, various types of evidence form a multiplicity that helps establish the truth in legal proceedings, primarily by providing a reasonable basis for the claim. Physical evidence is a silent piece of evidence that tells the story. Environmental clues weave a complex narrative, and expert opinions illuminate the complexity. But be careful with the words. Direct evidence does not allow for ambiguity. Demonstrative help intuitively brings understanding. Together, this evidence provides information that courts can consider to guide the path to justice. Law seeks the indisputable truth among all evidence and strives for peace and justice.